whatever system you choose to adopt, it has to be a one-person, one-vote system. It gets more and more interesting. Again, I ask myself a small question. Does paragraph 21 relate to Article 25A or Article 25B? Because if it relates to Article 25A, which defines the general right to democratic governance, as Professor Ramcharan just mentioned, then maybe if you read the Hong Kong Reservation carefully, not only does it not apply to Article 25A, it may not apply to a general rule of international law as opposed to the treaty rule. These are all rhetorical devices. I will say something about what the true effect of what I'm saying is in a while. I think earlier Professor Ramcharan talked about how we are in the business of persuasion. I think we are in the business of producing literature, persuasive literature, and engaging in the making of successful rhetorical devices that can be employed to change the societies that we live in. Let me go on to talk about small things first. As I said, I'm not very good with the big things. Paragraph 7 talks about the exercise of governmental power. It talks about the power of popularly elected representatives. And it brings into question whether the powers of those popularly elected representatives whether those powers are sufficient. Now, it has been said that the popularly elected representatives here in Hong Kong do not exercise sufficient powers. It has been said by a colleague of mine here in a very famous book of his, Professor Yash Gai. He says that basically the Legislative Council engages in the business of frustrating the adoption or implementation of executive policies. Now, in the previous administration here in Hong Kong, that was of course used as a reason to demonstrate that Hong Kong's actual situation made it unready for reform, that there was this unworkable legislative-executive relationship. But what general comment number 25 in the 7th paragraph wants us to consider is whether the powers of the popularly elected representatives are sufficient. And if they're not sufficient, this again may be a violation of Article 25. Now, paragraph 7 does say that these powers of one's representatives are to be laid down in laws and constitutional provisions. What it doesn't say is that once it's laid down in your constitutional provisions, it passes the test of Article 25. What it must mean is that your constitutional provisions would have to still pass the test of Article 25. To put it simply, what paragraph 7 says is this: the popularly elected body must either itself play a vital role in governing the state or be in control of that body, which is the state. And the question now is whether that is so in Hong Kong. There are many little paragraphs, paragraphs 6, 8, 25, and 26. They're not particularly interesting for us this morning because they deal with the citizens' direct participation in the conduct of public affairs through the free press, through other media, through public dialogue, through public debate. But these paragraphs do touch on one issue that might concern us all, the question of whether you have a right to a referendum in particular circumstances. You have to read into these paragraphs, but it is somewhere there, I assure you, in general comment number 25. So that's all of that relates to Article 25A, the right to democratic governance, in short. Article 25B deals with the right to vote. And paragraph 10 of General Comment 25, which seeks to interpret Article 25B, says the right to vote must be established by law. That right to vote must be subject only to reasonable restrictions, not restrictions that are unreasonable, not restrictions that impose literacy, educational, or property requirements. Now this, of course, relates to functional constituencies here in Hong Kong. It deals with a range of issues. It deals with everything from prisoners' rights to the legitimacy of the functional constituency system. This is something which the Human Rights Committee has been trying to engage Hong Kong on even before the handover. I think the first criticism was in 1995, where the Human Rights Committee said that Hong Kong's functional constituency system was discriminatory on grounds of property and on grounds of functions. There are also paragraphs in General Comment number 25 which deal with the right to stand for election. And the key paragraph is paragraph 17. If a candidate is required to have a minimum number of supporters for nomination, this requirement should be reasonable, and political opinion may not be used as a ground to deprive any person of the right to stand for elections. What are we thinking of? Is the 100-vote threshold in the election committee for the election of a chief executive unreasonable? Subjective, seemingly subjective question, but determined by controlling legal rules, apparently. You can also ask if the requirement that someone should be a patriot in order that that person can rule Hong Kong is a requirement based on political opinion. Because if it is, then general comment number 25 would say this is subject to international law as well. So that is general comment number 25. That has to do with Article 25. I will say something very quickly about Hong Kong's treaty reservation. The Human Rights Committee has not been saying for years that just because Hong Kong has taken the first step towards universal suffrage, that it must take a second step. That would make a pretty lousy argument. What the Human Rights Committee has been saying is that you don't have to have an elected legislature, and yes, you do have a treaty reservation. But once you choose to have an elected legislature, then you don't need that reservation anymore, because all that reservation says is that you don't need to have one. But now you've chosen to have one, that provision which relates to how elected legislatures are supposed to operate now applies, and that provision is Article 25. That is all the Human Rights Committee is saying. The Hong Kong government has come up with 4 basic responses. The first response is that Hong Kong has a system which is suited to its own circumstances. I call it the argument based on Hong Kong exceptionalism. Secondly, that the basic law and the NPCSC's interpretations and decisions are legally controlling. It is no different from a former Prime Minister of Thailand saying, what is the United Nations? It's not exactly my father, is it?